If you've been injured in the state of Maryland as a result of the negligence of another person, I handle every type of injury you could possibly conceive of. I've had traumatic brain injury cases with long-term disability. I've had disfigurement and dismemberment cases, sore backs, sore necks, any sort of orthopedic problem, even burn cases I've had before. I'm more than equipped to handle all types of injuries. In Maryland, the statute of limitations on most personal injury cases is 3 years. There's some exceptions to that rule, but the general statute of limitations is 3 years from the date of the injury or the occurrence. If it is an auto accident, and you may be entitled to what's called PIP insurance, personal injury protection insurance, you must file a claim with your own insurance company for PIP coverage within 1 year of the date of the injury. So it's very important. It's very important to make that claim timely and to see a lawyer in a timely fashion. If you were hit by another vehicle that was uninsured or underinsured, every insurance policy that's written in the state of Maryland carries a provision for uninsured and underinsured motorists. So you automatically would be covered and you'd have an entitlement to make a claim against your own insurance company. Your insurance company stands in the shoes of the negligent person's insurance company, and you submit the claim to them and you litigate the claim with them and adjust it as necessary. Typically, when establishing the value of an injury case, you look at several factors. Number one, the first one is the severity of the impact. How bad are these cars damaged? Insurance companies will look at small taps to a bumper and say, your client could not have been that injured, which is not always true. People can be injured badly from a low impact accident. But then you also have the catastrophic car wreck where people are cut out with the jaws of life. Obviously, the severity of the impact is an important consideration, and that's one thing that insurance adjusters look at. Second, any medical expenses. Insurance companies typically calculate your special damages, that is your medical expenses and your lost wages. They take that into consideration in determining how much a claim is worth. Third, maybe lost wages independently. If someone was out of work for over a year, that's a large measure of damages that the insurance company would have to reimburse you for. Another factor could be pre-existing conditions. If you have a pre-existing condition, the insurance company may argue, well, this injury is a result of his old football injury, his old trick knee he had from a lacrosse injury, not as a result of this car accident. It's important to get those old medical records and to get the new medical records and compare the two to see if the old injury is in fact aggravated by the new injury. I mean, there's typically only two roads to go down with a negligence claim, particularly an automobile negligence claim. Number one, you submit all the paperwork, and what I mean by paperwork is medical expenses, evidence of lost wages, the medical reports and invoices. You submit them to the insurance adjuster while you are quote, adjusting the claim. That's a pre-litigation posture. The insurance adjuster will have dialogue with you. We email back and forth, and we'll discuss what we think the settlement value of the claim is. If you cannot reach an amicable settlement in the case, then you have to look at the option of litigation. Now, litigation is very, very expensive. Expert witnesses, filing fees, deposition costs, all those things add up rather quickly. So the system is sort of set up to encourage settlements because the insurance companies know and the lawyers know that it's almost cost prohibitive to litigate some cases. Now, other cases, they may deny claims. They may say, we don't think these injuries are legitimate, or we don't think this accident caused these injuries, and you have no choice but to litigate the claim. Or they make an insulting settlement offer. The lawyer gets upset, the client gets upset, and then we go off to court and we file the claim. But those are really the only two ultimate means of settling or resolving a personal injury case in Maryland. If the insurance company does not offer the benefits and compensation that we believe after our analysis that you're entitled to, absolutely, we'd have to take the case to court, and I would have no problem doing that. In the state of Maryland, I've tried cases in the district court and in the circuit court in almost every surrounding county, particularly in Baltimore County, which is my home county. I've tried countless numbers of negligence cases in Baltimore County. If you've been injured in a car accident, you have a workers' compensation claim, a felony or misdemeanor criminal case, or a serious traffic or DUI charge, or some type of employment discrimination case in Annapolis, Ellicott City, Bel Air, Towson, Essex or Dundalk. please feel free to call me. Do not attempt to navigate the legal system alone. Contact the law offices of John Grayson Turnbull III at 410-321-8860 to discuss your rights and how to protect them. You can also visit www.johnturnbulllaw.com.